Okay, we'll get underway. Tēnā koutou katoa, ngā mihi mahana nui kia koutou I huri noa I te motu I tēnei rā. A big warm welcome to all of you joining us here today from your communities around Aotearoa. To settle us into the space, I'll open with karakia timatanga, which just helps us to bring us from the different places that we've come from in our mahi in our lives and move us into the space of learning and whanaungatanga here together for this session. Kia hora te marino, kia whakapapa pōnamu te moana. Hei huarahi mā tātou I te rangi nei, aroha atu, aroha mai, tātou I a tātou katoa. Hui e, tae ki e. So some of you I've met in this learning and development space before. For those I have not yet met, ko wai o. I te piwaki ahau I ōtautahi, kei te whanganui a tara ahau I noho ana. He Learning and Development Advisor I te Paiora SSPA ko Claire tōku ingoa. Please use the chat space to introduce yourselves. And we have a number of our lovely Te Paiora SSPA team here today with us, but Belinda gives her apologies as other mahi has pulled her away today. Thank you all for taking the time to be at this Kai and Kōrero Learning Over Lunch with Steph Gregor from the Office of the Privacy Commissioner to lead us through a session on privacy guidance for the social sector, including an overview of recent changes to privacy rules and an overview of the requirements relating to information sharing. And it's great that we can be offering the session during Privacy Week, as you can see from Steph's background. I'm going to hand over to Steph soon to introduce herself in the way that she feels best. So we've had a considerable interest in this privacy kaupapa, and the large number of registrants represented very diverse coverage of our sector and the aligned sectors, which really reflects how relevant it is for your mahi and why we want to tautoko any useful learning into this area. We will be recording today's session so that we can share it with our whānau who are not able to join us but have registered for this session. We asked you to share before the session examples of your own real-world privacy issues or challenges encountered in your mahi, as well as any questions or pātai you would like answered. So Steph has read all of these and has grouped them into themes so she can anonymously address as many of these as possible throughout the session. And as a substantial number of those pātai were asking about information sharing, we will offer our June Kai and Kōrero with Claire Ruru, who is an information sharing and privacy specialist, previously working alongside Steph at the Office of the Privacy Commissioner. And she's now with the Ministry of Education as a Principal Advisor for Information Sharing. And Claire was going to join us on this session today. So Claire, if you're about, just maybe do some love heart reactions for everyone so they can have a wee squiz at who you are. So we're going to open the registrations for the June K&K today, and Claire will be able to follow on to do some more deeper understanding and diving into the information sharing space. So I now want to warmly welcome Steph to introduce herself and lead us through the session, so she can have as much time as possible to cover all of the areas that you've offered us. So thanks, Steph.
Well, kia ora, Claire, and tēnā koutou katoa. My name is Steph Gregor and I manage the capability and guidance team here at the Office of the Privacy Commissioner. I'm just going to share my screen and then I will get into it. Okay, trust you can all see that all right? Perfect. Well, yeah, thank you so much for joining today. It's a real honour to be here, in particular in Privacy Week, best week of the year, in my opinion. Okay, so I'm going to run through a few things today. We've got about 40 minutes left, so some of it I'll go through at a bit of pace, but it'll hopefully be a good introduction for everything. So I'm going to start by getting everyone sort of on the same page about privacy. And so I'll talk about, what is privacy? What does the Privacy Act actually require? So I'll run through the privacy principles briefly. I'll spend most of the day talking about information disclosure, so sharing information in the social sector. I'll get to how I've addressed the questions that you all sent through, and thank you so much for that when I get to that bit. I'll then talk briefly about IPP 3A, where from the 1st of May, so 12 days ago, there's a new change to the Privacy Act about collecting personal information and what you need to tell people when you do it. So I'll talk about that a bit more near the end. So, like I said, I'm going to throw heaps of information at you at pace and probably in an overwhelming way. But just if you remember nothing else from this whole presentation, please just remember you can and should share personal information to keep children and young people safe or to keep other people who need support safe. So safety trumps privacy. That's my headline message, and I'll get more into that later on in the presentation. I'll also point out that the Office of the Privacy Commissioner has lots of guidance on everything to do with privacy, including information sharing and disclosure. It's all at privacy.org.nz. I've also set out throughout the presentation, I've got links to the specific guidance that goes into greater detail about the things I'm giving the introductions on. So I'll send those slides to Claire, who can send them out to you all as well. So you can go through those links to find out more. Think of this as sort of a bit of a taster rather than the full thing. Okay, so I'll start by going through the information privacy principles. So the Privacy Act applies to personal information. It's made up of a bunch of privacy principles that deal with how you collect, use, hold, disclose personal information. I know some of you will be subject to the Health Information Privacy Code, which is a code of practice which is made under the Privacy Act, which is for health agencies dealing with health information. I'm going to talk about the Privacy Act more generally. There's a few slight differences in the Health Information Privacy Code. For example, a bit more of a focus on authorization than there is in the normal Privacy Act. But to avoid it getting too confusing in the time we've got available, I'll talk about the Privacy Act. But just know if you're subject to the Privacy Code, most of the details are quite similar. We've got more about specifically the code on our website as well. So the Privacy Act, as I said, split up between collecting, holding, using, disclosing personal information. I'll start with collecting personal information, and I'm going to start with IPP1, IPP being short for Information Privacy Principle. IPP1 is sort of the bedrock that everything in privacy, is built on, which is about the purpose for which you might collect personal information. In general terms, what it says is that information that you collect personal, so information about people, about individuals, you should only collect if you have a reason to do it, so a good purpose to do it, that's connected to the functions of your organisation. Often the functions of your organisation might be quite clear. You do this kind of service, and these are the kinds of information that you need to order in order to be able to give someone that service. So that's your purpose. IPP2 is about where you get your personal information. And so IPP2 is the first of the privacy principles that has this concept that flows through the rest of them, which is the number one rule, followed by a number of exceptions below. So what IPP2 requires, or at least that headline rule, is that you get information directly from the person it's about where possible, unless a number of exceptions applies. And we can get to those later if we need to. And then IPP3 and 3A are quite strongly related, but it's about transparency and letting people know what you're going to do with their personal information. So IPP3 is about when you collect personal information directly from an individual. So they've given you the information about them in a web form, they've told you, they've sent you an email, whatever it may be, information you've collected directly from them, you've got to tell them what you're going to do with it. You'll probably have a privacy policy, a privacy statement, privacy notice, those kind of things that you already deal with within your organisation that sets out how information is going to be used. And that's just giving effect to IPP3. 3A is kind of similar, except it's about when you collect personal information indirectly. So when you collect it about someone, but not from them. So if you receive a referral, for example, then that might be an indirect collection. IPP3A is the one that came in on the 1st of May this year, which says that you need to let people know what you're doing with your information when you collect it indirectly, as well as when you've been collecting it directly. But similarly to IPP3, privacy statements, privacy policies are going to be your best friend here when you're thinking about how to let people know that you've collected their personal information indirectly. 4 is a principle about manner of collection, about being fair about how you collect information. I think this is kind of the don't be creepy when you're collecting information privacy principle. So if you're going to get something, just don't do it in a way that's too intrusive or anything like that. The next three are about holding personal information. IPP5 is about keeping personal information secure, so taking reasonable steps in the circumstances to make sure that you're looking after the personal information that you hold. Particularly, you'll be holding a lot of really sensitive information, so it's really important that you're taking good steps to keep it safe. But the good steps are often, they're not too much of a drama. Things like multi-factor authentication can just make a massive difference if someone is trying to hack into your system. If they don't have your phone as well, tough luck, you're not getting in. So things like that are a really good step when it comes to making sure that you're taking reasonable steps. If you are an agency if you're in the community, we also have a specific piece of guidance on our website that, now that I'm thinking about, I didn't even link up here, but it's called Health on the Road. And I'll send the link to Claire after this that she can send out alongside everything else. But what we talk about in there is lots of different ways that you can keep information safe when you need to take personal information with you out into the community. Because often you will need to do that, but there's some simple things that you can do to make sure that you're looking after it. Like, don't leave documents about people's health information on the dashboard of your car. Make sure that you've got things locked away properly, secured, and taking them back to your office as soon as you can, things like that. IPP 6 and 7 I see as sister privacy principles. So IPP 6 is the right that an individual has to access personal information that is held about them. So you might receive, people call it an access request, they call it a Privacy Act request, they might call it an IPP 6 request, or just an information request about them. Those all mean the same thing. So that's an IPP6 request where someone can ask you, what information do you have about me and can I have a copy of it? In most situations, the answer has to be yes, you can have a copy of it, but there are some exceptions to that where you might not need to give them the full information for certain reasons. That's all covered in the Privacy Act, and surprise, we've got guidance on our website about it. If you receive a request and you don't know how to handle it. IPP7, I think, is the sister because that is the correction obligation of an agency or right of an individual. If an individual thinks that the information that you hold about them is wrong, then they can ask you to correct it. You might not agree that it's incorrect. There's ways that you can handle that as well, but that's what that IPP does. Final stretch on IPPs. Fairly long final stretch because we're only about halfway through. But IPP 8 is the accuracy privacy principle. So if you're going to be relying on personal information, you've got to make sure that it's right. You will not make a good decision if you're making a decision based on information that is wrong. So it's taking reasonable steps to make sure that the information is correct. Could be as simple as about, do I know this information is definitely about the person that it relates to, for example. IPP 9 is the retention privacy principle. So it's about how long you keep personal information once you've got it. The big rule there is you keep it as long as you have a lawful purpose to have it. If you are subject to the Public Records Act, that makes the retention quite easy to figure out because whatever your disposal schedule there is, that's when you get rid of it. Similar if you have a general disposal authority, if you are a health agency, that will help you figure out the retention. IPP 10 is about what you can use personal information for. The headline rule is use it for the reason you got it. If you say, I'm using it to provide you this service, use it to provide someone this service. There are, as with all of them, a number of other exceptions for different reasons where you might want to use it for certain reasons, and sometimes that's allowed. IPP 11 is about information disclosure, and so we'll spend most of the rest of the presentation on this one in particular. But the headline rule, only disclose personal information for the reason you collected it, unless. And I'll get into the unlesses in a bit. Then IPP 12 is about sending personal information overseas. Basically what that means is if you're sending it to an agency in another country for them to do something with, you need to be confident that they're going to look after it in a way that is similar to how we will. I won't talk about that too much right now. And then 13 is about unique identifiers, or specifically about reassigning unique identifiers as a primary identification mechanism for your agency. If you have questions about unique identifiers, there's stuff on that on the website. It's complicated. I don't have a favourite IPP, but I have a least favourite. It's probably IPP 13. Okay. that's that. So now we'll get into sharing information, and this is what I'll spend most of the rest of today talking about. So I'm talking about disclosing personal information about someone. I'm not talking quite about IPv6 requests, but I've got something about that in a sec. But basically, when it comes to sharing information with another agency or with another individual about someone you're supporting, there's a few situations that you might find yourself in when it comes to information sharing. Do you have to disclose something? In which case, well, that's easy. Disclose it. Do you want to disclose something? There's a process you can follow. Have you been asked to disclose something? That's also something you can deal with in a slightly different way. So when you sent through the questions that I received via when you signed up for this, there were some themes that I noticed came through a lot. The first is, how does the Privacy Act interact with other legislation? The second is, how can we share information safely? How much information should we be sharing in particular circumstances? What do we do in multi-agency meetings was another. And then one about responding to access requests made on behalf of children. So that's where a parent might be asking for all information you hold about my child. Sometimes this can get tricky because there might be some sort of a custody dispute. You're not sure that what the motive behind the request is. We've got specific guidance on dealing with that I think you'll find quite helpful. So before I get into it in more detail, I guess I'll start with this number one question of, how does the Privacy Act interact with other legislation? So Section 24 of the Privacy Act essentially makes Privacy Act a kind of subservient piece of legislation to other legislation. So what that means is, if another piece of law says that you must or that you may do something, then that becomes your authority to do it rather than the Privacy Act. And so what I really want to sort of hammer home is that don't get yourself in a situation where you think, I could have helped someone, this could have, prevented some harm happening, but I thought I couldn't because of the Privacy Act, because that's not what the Privacy Act is doing. The Privacy Act is giving you guardrails, but it's not saying don't help people. I've got here a bunch of links to specific bits of guidance on the website, some of which I'll be talking to a bit now, and the rest of which, if your question related to this, you could click through this link. So we've got guidance about multi-agency meetings specifically on the website, which Claire Dodo, who is online here, led the charge on when she was at OPC. I'll talk about it briefly as well. We've got guidance there about information sharing to protect the wellbeing and safety of children and young people. I'll talk about that a bit more, both as it applies to children and young people, but there are bits that also apply to wellbeing of adults. Got some general guidance there on sharing personal information, including if you've had a request by the police, for example, for certain information. We've got a decision tree, again, a Claire Dodo special, about a legal framework for figuring out in what situations you should rely on what legislation to share information. Got specifically their guidance about responding to requests for a child or young person's personal information. So that's the IPv6 thing. But the sort of too long didn't read of that is that you've got to put the interest of the child at the heart of it, and we kind of work through the steps that you can take to figure out how to do that and how to give the information safely. I also want to plug something that Claire is giving this Friday, a webinar on information sharing in particular, which is on this Friday at 12 p.m. until 1 p.m. So I'm going to still give you the overview of things to do with information sharing, but she'll be focusing a lot on use cases, which might be quite helpful to see yourself in when you get to that. So this hopefully can be a bit of a primer to that, and then that will be an extension of this. And then she's also giving a K&K June talk in June, where again, she'll be following on from my presentation today, where I'm introducing the concepts, talk about it at a general level, and she'll be able to run through some specific use cases that you'll be able to use the information that you've gained today to make that even more clear next month. Also in the guidance, there are lots of use cases in there about when these kind of information sharing mechanisms might be well used. So that is all in greater detail than I can today, but I'll do what I can in the time I have today. So the thing I would like to start with is that all agencies should have a disclosure process. If your agency doesn't, then this is the perfect opportunity to get that sorted. The kind of hierarchy of information sharing goes, if you've got to share it, you've got to share it. If you want to share it, you need to have a process to do it. And then the way the different laws work on top of each other, I'll be getting into. So the first thing I recommend doing in a disclosure process is actually identify the situations where you are legally required to disclose information. For example, if you receive a request under Section 66 of the Oranga Tamariki Act, either by Oranga Tamariki or the New Zealand Police, to ask for certain information for certain reasons, you must share it. So that makes the decision-making incredibly simple for you. You must share it, okay, you share it. So that. The second, if you are considering disclosure, you need to consider whether another law specifically permits disclosure in that case. If so, just rely on that law, don't worry about the Privacy Act. And then the third, which is sort of the backstop for information sharing, is that if no other law applies, then consider IPP 11 or Rule 11 if you're subject to the Health Information Privacy Code to govern that sharing. So how does that even work? If another law says you must share, you must share. The main thing with information disclosure is that you need to have a legal authority to share information, but that legal authority can come from heaps of different places. So the first is that, it's like I was talking about with Section 66, if you've got to share it, you've got to share it. So send it. The next one is if another law says that you may share, you can use your discretion about whether to share based on that law. So that law is your legal authority. You don't also need to think, oh, but the Privacy Act wouldn't let me. The Privacy Act, IPP 11, is turned off at that point. You just rely on this other piece of legislation that says you can share the information. So, for example, if you, I've got up there Section 15 of the Oranga Tamariki Act, which is if you are concerned about any of those things there, about a child or young person might be being harmed, then you can report that matter to a chief, to a constable or the chief executive of Oranga Tamariki. So that is your authority there. When I say safety trumps privacy, if you're worried about a young person being in harm, you can report it to someone who can help in that situation, maybe a police officer. There are also some specific sharing mechanisms that might come up for you. This first one specifically about children, which is Section 66C of the Oranga Tamariki Act. So what Section 66C does, and I'm probably really small on your screen, so you probably can't even see my clipping that well there, but it's about using and disclosing personal information relating to children or young people when you are doing it for reducing the risk of their harm, but it's also broader than that. When you're dealing with a risk assessment, that's information that you can share. And so it's a voluntary sharing provision between agencies. So it's child welfare and protection agencies or independent persons. We've got in our guidance some information about how you can figure out if you are one of those agencies. Most agencies, if you are one, you'll probably know it. So you can have a look into that. But this allows sharing to support young people in a broader than just with Oranga Tamariki or just with police or just from them. It's with other child welfare and protection agencies. It's also a bit broader in its scope than just immediate, imminent harm, dealing with that. So it's about well-being, prevention, rather than just crisis management. You can either share on request or you can share proactively. There isn't a requirement for consent, so there's not an authorization side of things, but you do need to consult before sharing unless it's not practicable or appropriate to do so, which is all sort of legalistic words for you've got to at least consider whether you are going to consult, and we've got information on our website about how you might do that. So if you've got information that you want to share with another agency to support a child or young person, dealing with a support plan for them or their family, anything like that, then you can do that under Section 66C. You'll note here that all of the other IPPs are not turned off. You still need to make sure that you're dealing with accurate information. You've got to make sure that you're looking after it properly, all those kind of things. But for the sharing with other child welfare and protection agencies, you are protected if you share in good faith. So this information disclosure process concept will be really helpful for that, because you'll be able to figure out when it's okay to use this, and if you're in a multi-agency meeting, what that actually looks like. There's another one here. I've got it under the Protect Children thing, but it's broader than just children. It's not just about children or young people, but it's Section 20 of the Family Violence Act 2018. So it's got a voluntary information sharing provision specifically for people, which includes children, but it's not just children, who are experiencing family harm. So that applies to both victims and perpetrators of family harm. It's about sharing between family violence agencies and social service practitioners. So it's got some principles there guiding decisions on whether to disclose. And again, when you get these slides, you'll be able to see a bit more closely the screenshots there. But it permits sharing if you are doing so in order to mitigate a family violence risk. There's also a specific duty there to at least consider sharing, so you should at least be thinking about it, and consent is not required. So again, there's another one that is you're protected if you share in good faith. So what I'm trying to get across with that is there are lots of different ways that you can share personal information to keep someone safe. And if you're worried, oh no, but the Privacy Act says that I can't, doesn't matter. If another piece of legislation says that you can, then do, or consider it at least. I know I'm really labouring that point, but that's the thing that I really want to get across there. We've also got this helpful overview about the three different kinds of sharing, three key ones within the social sector. So the Oranga Tamariki Act, the Family Violence Act, and then the Privacy Act. So the order that you'd probably want to do if you're concerned about someone's well-being or if you want to share some information to support someone, if there's something to do with well-being or safety concerns about a child or young person, consider using the Oranga Tamariki Act provisions. If the child or young person or their family, so any person, is subject to family violence, consider the Family Violence Act. If neither of those apply, then have a look at IPP 11 of the Privacy Act. And there's quite a bit in there that you could still rely on. So the first is purpose. So the reason that you got the information in the first place may have been to share it in certain circumstances. But there are also a bunch of exceptions to IPP 11 that might mean you could share the information even if it's not for the purpose that you collected it. One key one is that the serious threat to life or health of an individual, which is either the individual the information's about or another individual. So there's versions of this both in the normal Privacy Act, so if you're not a health agency, and in the Health Information Privacy Code, so if you are a health agency. So if you are concerned that there is a serious threat either to public health or public safety or the life or health of an individual concerned or another individual, you can share the information with someone who can help with that. So you have to be confident that the person that you're sharing only as much information as you need to get help for the person or to get help for the person that you're worried about, and with people who can actually do something about it. At a multi-agency meeting, that might be a situation where there are people that will be able to help with that, but you just need to turn your mind to it, those kind of things. I'll go back here to the multi-agency meeting in particular. The reason I've laboured this one quite a bit today is that a lot of the questions that came through were about how do we deal when we've got a bunch of different agencies in the room. We don't know exactly what they are each doing. How do we even approach this to protect the person, to support the person without breaching their privacy? Well, good news, we've got heaps of guidance on it. So this specifically deals about sharing information at multi-agency meetings and having an information sharing protocol. We even have a template about how you can put that information sharing protocol together. So what I'd encourage is if you know that you regularly have multi-agency meetings about particular issues or with particular other agencies that you regularly deal with, maybe this could be a good prompt to have a chat with them about how you're actually going to deal with those multi-agency meetings. If you put together some sort of standing protocol, you do it once and then you just do it every single time that you have a multi-agency meeting about whatever you normally meet about. So that's something that I recommend. Put some time in now to just sort of get the thinking down about how you'll approach these, and then that will help you be able to do it on an ongoing basis, and then you also don't need to reinvent the wheel every time you are trying to think about whether you can share this information. Just make that available across your organisation. You might find that incredibly helpful. That's my introduction to that. I think if you come on Friday, or if you come next month, to Claire's presentation about this, she'll be able to work through some use cases. Or like I said, the use cases that are already in the guidance might also be helpful for you to have a look at. So how many times can I say this? 1 million and I'll never stop. Safety trumps privacy. Every single time. If you're concerned about the immediate safety of a person, you can always share information about that concern with somebody that you believe will be able to help the person who is in danger. That's not a qualified statement. You know, it's not a only if then. It's just if you are worried about their safety, you can share the information with someone who you think will help them. Okay. That's my quick introduction to information disclosure, and I'm making sure to just leave time for questions at the end. So then the last thing that I'll talk about before I get to that is about IPP3A. So I mentioned that briefly at the start when I was running through the IPPs. Now that IPP3A is in. But basically what IPP3A means that if you collect personal information about someone indirectly, you got to tell them. There are some exceptions to this. Those are set out in the guidance. We also have health agency specific guidance if you are a health agency about how to do this. But the kind of key thing there is don't panic too much about it. Just have a think about what personal information you collect and why, whether directly or indirectly, and then just have a look at your privacy policy to see if it's covered. If you have any sort of onboarding documentation when people come into your service, then maybe that's a good opportunity to be able to include some information about what you're collecting and why to meet your IPP3A requirements. As well as the specific links that I'll send out to Claire, there's also some additional resources on our website. Plus, I've got another 10 minutes or so to take questions. So we've got Popo Matatapu, which is a big how to do privacy well kind of not presentation, it's a piece of guidance we've got on our website. We have a lot of case notes about information disclosure as well as anything else to do with privacy, about things we've seen and how we've dealt with them. Got a lot of e-learning modules on our website, which might be helpful for your broader organisations as well. That's all available at privacy.org.nz. So I'm just going to have a look in this chat.
Steph, I'm not sure if you can see the one at the end from Alex. What about wellbeing of customers, for example, not children, which you covered somewhat, but perhaps more specifically you could answer that one.
Yes, sure. So if there are not specific, so the Ōranga Tamariki Act in particular is focused on children, and rightly so, but for other well-being of individuals, there's other things that you can consider as well. If you're a health agency, I think it's 22F of the Health Act has certain information sharing abilities in there. There's also all of the other stuff that I was saying about how IPP 11 works still apply to adults as much as they do to children. So if you're sharing it for the reason that you got it and you're told them that at the time that you collected it, if you know that you regularly work with other agencies to support well-being, that's the kind of thing that you could front load whenever someone comes into your service, or have it on your privacy policy on your website, or just chat with them about it, those kind of things. Then you could share it with other agencies for that kind of wraparound style support. So purpose is one way to deal with that. Another way to deal with that is one of the exceptions that exist under IPP 11 of the Privacy Act. If you're concerned about a serious or imminent threat to their health or safety or those of others, yep, you can absolutely share that. There's a number of other exceptions that might apply then as well. Okay. Oh, hello, Elizabeth. Can a person holding an enduring power of attorney for another, e.g. parent, ask for historic foster care information about that person. A very specific question there, but I suppose the thing with an EPOA is that if they are, depending on how the EPOA is working, if they are essentially acting as the representative or in the shoes of another person, then yes, they are able to make Privacy Act requests on their behalf. There's also, even if it's not an EPOA, if it is another representative kind of situation where someone has authorised someone to be their representative, then yeah, they could ask on behalf of that individual as well, including about historic foster care information. Yeah. Okay, Ruth. So I'm just reading these as they come in. So it just takes me a second to get my brain to it. If you gather information indirectly via a multi-agency meeting under Section 20 of the Family Violence Act, does IPP 3A apply that you have to inform person what information you have gathered and what you will do with it? Great question. So yes, IPP 3A does apply to all personal information that you collect indirectly about an individual. But that's not the same thing as when you collect the individual, you then have to go to the person and say, oh, and by the way, we got this. So I think there's a few ways that you'd be able to deal with that to make it a bit more manageable, which is if you've got these routine collections where you know that you always have these kinds of meetings about these kinds of issues with these kinds of agencies, that's the kind of thing that you could put in your privacy policy where you say, we do those kind of things, and that would probably be reasonable steps in order to tell the individual. The other thing is that if you have a direct relationship with the individual, you might also be in a good position to just be having that chat with them as well as part of the whatever the care is that you're giving them, and say, we have this and we got this information in order to be able to support you in this kind of thing. There's no requirement IPP3A to say exactly where you got the information from, just that you've got it and for what purpose. So as part of that direct care, you might be in a position to want to be talking about that. But the whole way a multi-agency meeting works is that not every single person is then actually contacting the individual. And nor would we expect them to. So it's about making sure your privacy policies are up to date, and probably whoever actually has a relationship with the individual might be in a position to sort of explain things if that's appropriate. Sorry, Alex, I see another question. I see a question there, but I'm not sure if I understand what you're asking there.
I think, is it correct, Alex, that you're extending on the previous question asked about the well-being of customers, for example, not children? So, for example, if a landlord and you have a tenant that might be in prison or a mental health facility?
Yeah, so you're wanting to share, or you're wanting to indirectly collect in that situation? So I suppose, so collect. Okay, yes. So that goes back, I think, to that general purpose thing. Why would you want to know that information? And you can probably, when I'm saying that, the answer might pop into your head. I need it for this, and this reason. If that's the case, then you can go back to that IPP1 stuff about why you can collect information if it's about a particular purpose. And then that gives the authority to collect it. Yeah, so a tenant may be in prison, but ascertaining information can be difficult. Yeah, I suppose the thing to do there is think about what information you need and why. I understand that sometimes it is hard to, because you don't know where to get the information, or where you're meant to get the information from might not necessarily be forthcoming. So that can be kind of tricky, and I appreciate that. I don't think that's actually sort of a problem that the Privacy Act itself can solve. So the main thing there is that if you know why you want this personal information, why you need it for your lawful purpose, then you are able to collect it. Does that answer the question? Thanks. I can't see any other questions there, so unless anyone has one.
And Whānau, feel free to take yourself off mute if you'd rather just ask verbally.
Hilda, I've got another question, if that's okay.
Yes, go for it.
It is specific around the multi-agency meeting stuff, so I know that might be answered in the future webinars, but just in case, I thought it'd be worth asking here. So if you're at a multi-agency meeting and under the Family Violence Act, same provisions, you're entitled to take or you're there under that provision of the Family Violence Act, sharing information, but the information is about a person who you're not currently working with, your service, and you're not tasked directly with any task to directly engage with them out of that meeting, but you want to gather that information because they may well come through the door of your service, thinking about health, really wide service, that the next time they come into health, that you want to gather that information and take it and put it on your database just in case, which having read the guidance, it says, no, you can't do that. But under, yeah, I just wondered if there was provision to do that, to take information for when that person may well come across your door next, because they have been open to health, but they're currently not. Does that make sense?
Yes. Yeah, that does make sense. And of course, I can't give a specific answer to your specific situation. But I think in those kind of things, yeah, the guidance is pretty clear. If you are not covered by the provisions that it's dealing with, then you can't collect it under those provisions. You would need to have some sort of other legal purpose to do that and to be getting it in a particular way. Claire might be able to talk a bit more about this at her situation, at her presentation, sorry. But yeah, there's no, that's how that goes. Yeah, thanks, Ruth. I can see there's one other question. Shall I just go to that really quickly and then we might be out of time here?
Thanks, Steph.
So if a psychologist needs to know a child's trauma history in order to plan suitable interventions, it would be legal for OT to share details of the history. So I think there's a few ways about those things. So there's the reason for you to collect it. So as a psychologist, you'll be covered by the Health Information Privacy Code. And so there's some collection things there that you could, ask for that information under. As for orangatariki, sharing the details of the history, I actually don't think I'm going to be able to have a good enough answer for you in the next 1 minute that we have, Mandy. That might be another one that has to come back for Claire. So I'm really sorry about that. We are sort of running out of time and I don't want to give the wrong answer on the fly.
Thanks, Steph, and Mandy will certainly scoop up that question so that we have it available, and if you are available for the June K&K, otherwise we can get back to you directly on that so that we don't miss that opportunity for you. Oh, thank you so much, Steph, and amazing keeping to time as well. Really appreciate you sharing your expertise and your rich mātauranga of this kaupapa. It's such a chunky topic, and who knew there were so many IPPs? I certainly didn't. Being able to condense it in this time frame and also make it so digestible and directly relevant with some very useful examples. Thank you so much. At Te Pai Ora SSPA, we do want to know whether you're interested in diving deeper into this privacy area. So as you exit Zoom today, there's just a really brief 1-minute survey so you can leave us with a response if this is an area that you'd like us to do more around. I'd also like to share our slide now. I'm just going to replace you, sorry, Steph, so I can share the slide. And hopefully I can also grab Claire onto Spotlight so that you know who you will be seeing. Where have you gone, Claire? Has Claire had to jump off?
Oh, no, I'm here.
Oh, Kate to Pi.
I'm
Thanks,
just not
Claire.
sure what screen of the meeting participants I'm sitting on at the moment.
Kate to Pai. So as Steph mentioned, our June Kai and Kōrero session will be on information sharing, where Claire is going to build on the foundation that Steph has offered here today with more specific case examples and helping attendees work through these real life cases. So I'm certainly looking forward to hearing more from you, Claire, about the decision tree Claire Ruru special that Steph mentioned. No pressure. And we are actually opening registrations for that June K&K today. So Charlotte's going to share a link in the chat if you want to jump straight on before you jump out of this session. So thank you again, Steph and Claire, for both being here today with your rich knowledge. I am going to close as we're now at 1 o'clock as we began to send you all back into your spaces wherever you're moving into, at work, at home, or into other life with a karakia whakamutunga. Kia whakaere te tapu, kia wātea ai te ara, kia tūruki whakataha ai, kia tūruki whakataha ai, haumie, huie, takie. Thanks everybody. We'll see you again soon.